Hi there, folks, and this is Sam Price, and welcome to another episode of Probate Notes. And I have with me today attorney Courtney Writer. She is a vice president of trial litigation counsel with Fidelity National Title, and she's going to be able to give us some insights on how title insurance affects probate matters. Courtney, thank you so much for being on with us today.
Thanks so much, Sam. It's a pleasure to be here. Happy to kind of be a part of this and happy to be able to share my knowledge
Thank
and
you.
things of that nature. So,
I'd like to maybe just kind of start out with talking a little bit about you. Where are you
okay.
from? What's your background?
So I'm originally from the San Dimas Glendora area. And I actually went to high school out there. I went to St. Lucy's High School. I played basketball. Then I did my undergraduate degree at UC Riverside, got my degree in political science with law and society. Then I went to law school at Southwestern and passed the bar in 2015. Um, and then just to give a little bit of insight into kind of my experience and knowledge, my first job was actually at a real estate company. Then I ended up working there for throughout college, and then I had always wanted to go to law school, um, and so I ended up leaving there to go to law school at Southwestern, and then again graduated in 2014, passed the bar in 2015, and then ended up doing personal injury for a little bit for the first about 3 years of my career. And funny story, just going back to, how I started to work for Sam, I actually was kind of over personal injury and was looking to get into
Why?
yeah, I wonder. Um, and was actually looking to, get into, a different area of law. And, so I was looking for another position. I ended up finding, the job listing for your firm. Again, you were looking to hire, your first associate and ended up, responding to that. We had our initial interview, and then I ended up, uh, you know, going back, because I was still employed at a personal injury firm, ended up going back and just happened to get laid off. Our whole department got laid off. Um, the right the day after I initially interviewed for with you, and then I had my second follow-up interview with you and got offered the position there. So it just timing was everything and it worked out. That's where I got my initial experience in probate and estate planning, working for Sam for I think close to 4 years. And then I ended up getting an opportunity with Fidelity National Law Group, which is the in-house litigation division of a number of different title companies, Fidelity National Title Company, Lawyers Title, Tycor, Commonwealth, Chicago. We're probably the kind of biggest competitors. Our biggest competitor is probably First American, so we're kind of up there. We're kind of the two, uh, I would say, the two main players in the title industry. And then I've been doing litigation for them for over 5 years. It was actually just over 5 years. Um, and uh, I actually, my focus, because I am a certified specialist in probate, trust, and estate planning, my focus is uh, basically title litigation that does involve probate. I'm kind of their go to, at least for the LA and Southern California area, and sometimes Northern California too. We have an office in Walnut Creek, and sometimes my colleagues up there reach out to me regarding probate. So that's kind of just a general background about me and how I kind of got into the title industry. I have background in obviously real estate, and then obviously I have background working with you, and becoming a certified specialist in probate, trust, and estate planning.
This third party buyer in our little hypothetical here
Mhm.
buys that house for $500,000, gets a $500,000 owner's policy, but also gets a mortgage against the property, puts down 20%, $100,000, and gets a $400,000 mortgage. There would also be a $400,000 lender's policy. So there's two title insurance policy against this property. Now, if grandson is successful in overturning this transfer and says, really, it should be back in the estate and I should have a third, and I actually want the property, what would the title insurance policy be on the hook to pay for?
So the title insurance policy would be on the hook to pay for probably both. They would need to make sure that the owner was whole, and then additionally make sure that the lender was whole in the event that their title or their lien interest is um, subject to kind of a challenge, a valid challenge, as you had mentioned. So we would be on the hook for probably two different policies in that scenario. Absolutely.
So pay off the mortgage lender so that now the third party buyer does not have to have a mortgage to pay, because
Right.
the lender's policy would pay off the mortgage.
Right.
And then secondly, the third party buyer put $100,000 down, so he would get his $100,000 back.
hmm hmm
Okay.
Exactly.
So that's one scenario if grandson
Yeah.
could overturn that transfer.
Yep.
So you've got this third party buyer and you want to keep your buyer in the property. The lender wants to keep their loan, but you need to pay off grandson.
Yep. Exactly.
How much would the title company be on the hook for grandson
So it
potentially?
would be up to the extent of the policy. So that would be our obligation. And it would only be one policy. It would probably trigger only the owner's policy, like the value of it. And then a lot of it has to do another thing that kind of leads into this same scenario is I'm not sure if you guys touched on this in previous episodes, but the grandson would only be entitled to a third of the value of the property as of date of death.
Yes.
So, and that's done through an what's called an inventory and appraisal, an INA, that is done theoretically should be done during the initial probate process. And so our title insurance policy would only be obligated up to a third of the value of the property as of date of death to the grandson. So what we would do in that scenario, to fully answer your question, would be we would probably be able to negotiate some type of settlement. And a lot of times that's really how it shakes out, to be quite honest.
Yeah.
The grandson lives in another state and doesn't want anything to do with California property. He just wants their money. And typically people that kind of co-own property don't want to co-own property anymore, want their money, right?
Yeah.
And so what we would do is
Nobody wants 1/3 of a house that they don't live in. They want the
exactly.
money.
Yeah,
Yeah.
exactly. So what we would likely do is negotiate some type of settlement with the grandson. And that would be, a standard regular settlement agreement release. And then we would also need to get the consent of obviously the other two parties involved in the probate, or everyone entitled to notice. And so how we would do that is we would likely do a petition to approve a good faith settlement with grandson and give everyone notice if they would want to object to the settlement. Give everyone notice and an opportunity to object, and just have the court kind of rubber stamp it. And then also have the court enter some type of order confirming title in our insured client's name to clear the title issue. Because what we would want is some type of recordable document um, that we can record with the county recorder's office, confirming the correct title. And that's what we would need.
Any last case scenarios that happen in the probate world that you wanted to tell our listeners about?
I mean, we covered a lot. I think we covered the main ones that I see kind of the most often, which would be 850 petitions, kind of missing interest, um, issues with the property not being properly transferred into a trust. But sometimes there's really each case kind of has a life of its own, I will say. And each case is different. And so
Sure.
you just have to take the facts that you're dealt and kind of proceed. And that's the fun part of litigation. I know you do probate litigation, you see something different kind of every day.